Okay, good afternoon. And welcome. All right. So um, we have a question that was posted on e-learning for this week's tutorial. But before we get to that, I want to check in with you guys and find out what you feel like you learned in last week's lecture. And also to check in and make sure that you guys are, if there's anything that you don't feel was clear from last week's lecture.
Sir, can you repeat your questions, please?
Sure. The question is, what do you feel like you learned from last week's lectures? And is there anything that you don't feel comfortable with, you're not clear on?
Oh, well, basically we went through what is a tort, what breaches the role of policy, and
Was there something else, or was that it? You sounded like you were continuing and then you cut off.
yes, please, I was continuing, but my sisters. Right, so then we learned negligence, and then what is the breach of duty and the reasonable man in certain cases. This is not necessarily like last week. This is just like in general what I understand or stuff that I understand.
What did you learn last week? Right. The question was specific as to time. And there's a reason for this, right? I'm not just being a jerk about it for no reason, I promise. So
Um, I am in the middle of work, but I'm gonna try. I believe you may have gone through the elements of proof that go into the tort of negligence. You said that there are three elements: existence of a duty of care, breach of that duty, and the damages caused by that breach. And that you said that there were issues related to that in terms of causation and remoteness, which limit the scope of that duty of care. And then did some cases around that, looking at some different tests and the progression and a comparative analysis between what was established earlier up in terms of Donahue and Stevenson. And then we looked at, I believe it was the Caparo test. And then there was something around the modern tests for determining the duty of care. And we looked at some cases there. I'm a bit murky in terms of that one. Because I haven't got caught up with all the reading, but we looked at some cases there in relation to how the Toombs v. Mitchell case and some others would apply to establishing what the duty of care was and what tests are involved in assessing that.
absolutely right. Perfect. Well done. Paul, your hand is raised. Go ahead.
Yes, Dr. Krell, good afternoon. Just a quick question. So we saw the transition between Donahue versus Stevenson, Ans versus Moulton, and then Caparo versus Dickman. is it a case that Donahue and Stevenson and Ansmerton is bad law and Caparo is the one that's acknowledged, or is it that all three are used to determine?
The answer to your question is that my reading of the cases is that none of them are currently good law. However, the current Caribbean standard appears to be a step behind the UK. So the UK has gone beyond the Caparo test into the Robinson and the Poole-Burrow cases, which are on the worksheet, but which, if you check the dates, you will find that they both came out after Professor Cotellini's most recent revision of the Caribbean tort law textbook. So they are not included in that book, quite reasonably. But those are the most recent statements of how to determine whether a new duty of care should be imposed. And I would take the position that the Robinson case, I would describe the Robinson case as granting discretion to judges to more or less find a duty anywhere they see fit, right? For as long as they can link it to a pre-existing precedent. But there's no, like, part of the problem is that, and one of the things that the Robinson court points out is that lower courts had been using Caparo sort of as a checklist. And there are, and the Robinson court's holding is that that is an improper use of that precedent, and to sort of push courts back in the direction of doing a more precedent-oriented and holistic analysis. Part of the problem with this is that the cases don't provide as much guidance as I think their authors hoped they would. And so then what happens is the lower courts are trying to make sense of what they've been given, and then a later authority comes along and tells them that they've been doing it wrong. And I think that that cycle has sort of repeated several times, and at some point it would be great if their lordships could figure out that, hey, we actually have to be clear in what we're saying about how to determine the duty of care. So Paul, does that answer your question? I feel like I rambled at you a little bit, but
You answered it, yes, thanks.
okay, good. Okay, so what else do you guys have that you're not quite clear on from last week in particular? Nothing? No questions. Okay. Last chance. Okay. So with that,
Sorry, not,
oh, I'm sorry. Go ahead, Carla Ray.
not from last week. This the one on breach of duty. Some areas were a little murky, but I haven't done all the reading, so
Well,
I'll wait till after that.
we'll be talking. We'll check in on that next week. So if you're still unclear after you've done all the reading, you'll get another bite at the apple next week. No worries on that score. All right. So with that done, let's move on to the question posted in e-learning. And you were asked to prepare arguments regarding a proposition. You were asked to prepare arguments on both sides. And the proposition is that contract and criminal liability sufficiently deter negligent conduct without the need for independent causes of action in tort. Okay, so it seems to me that the argument in favor of the proposition is harder. Okay, you're arguing for a movement away from the status quo. It's that always presents complications. There's other issues related to this. So let's start with that as the hard side. And so let's, if I have to call on people sort of at random, I will, but you guys are more than welcome to volunteer first. So if anybody wants to offer what they have, then we're all listening with great anticipation. Nothing? No one? So, so I'm getting a private message that folks were unclear on what the call for the tutorial was. I'm a little concerned about this because if you go on to the course website, there is a thing, and there's one for every week that we're doing tutorials, and it says tutorial questions. And so I'm a little concerned that if and let me be clear, I'm not concerned that you prepared the wrong thing. I understand the confusion. What I'm concerned about is that if you were confused about what the right thing to prepare was, why you didn't ask me what the right thing was. And that's and what concerns me about that is that I'm worried that you guys don't feel like you can ask me your questions. And so I'm very concerned that I have given you the impression that I don't welcome your questions and your correspondence. So that's what has me concerned. So for future reference, right? Well, that's very kind, Rhea. But for future reference, right? The thing that you look for in any given week is the thing on e-learning that is marked tutorial questions. That is where I will be posting the thing that I will be drawing on, right? There are other things out there that you may, the worksheets contain questions for discussion, and sometimes I may be using one of those. But I'll always post what I'm using on e-learning in a separate place. That's it. That's not the worksheet. Okay. All right. So we have a question. In the case that A stabs someone, criminal liability would already be in place, being grievous bodily harm, which is a crime against the state. So in a way, I could see why it would deter someone from bringing an action in tort. Not only that, but are many people aware of actions that can be brought about under tort? So what do we think about Tamara's point?
Sir, my name is Tamira.
Tamira, I am sorry. Thank you for
No
correcting me.
problem.
So what do we think about Tamira's point?
If I may, I will speak to the latter part of it relative to knowledge and awareness that actions can be brought. Culturally, if you look at the Caribbean, we're not litigious, one, and generally you find...
yeah, I don't really understand that. What's up with that? Y'all are weird.
Thank you for the compliment. But generally, I think it's because of the distance that is placed between the courts and society. So persons, there's a wall that sometimes seems impenetrable. So persons don't know that they have access to the courts for the civil side. They're more familiar with access on the criminal side because the state pursues its interests, and the average person is not availed of the opportunities that exist for them to get redress from the court on the civil side also, which is why
where do you think that wall comes from?
It's cultural.
I ask that sort of. Okay, can you expand on that? Because that covers a lot of ground.
Colonialism in a nutshell, I think, and the history that we have with the courts being British and tied to class and affluence and all those things caught up in there, and the legal profession being seen as something of privilege and not accessible and available to those of little or no means. And it's a major sociological construct that's tied in there. So I can't really synopsize why, but there are lots of historical and cultural underpinnings there in terms of how law evolved and how the courts were structured, and the access, even if you look from the civil side in terms of the magistracy, in as much of a lot of the matters are brought before the magistrates courts petty civil matters can be brought before the magistrates court. You find citizens don't even access it, although it's there and they can go and represent themselves without counsel. A lot of people don't even know that. So it's a lot in there involved in that. I'll mute my mic now.
Okay. So I think these are really interesting and useful, and in the question that that criminal liability can replace.
Sir,
yes, go ahead.
Not to cut you,
Tamira.
can you please repeat, because you stuck. You were stuck.
Okay. Sorry. My internet connection is not great. Thanks, Flo. Anyway, so as I understood Cassian's point, the argument is that it may make sense to replace tort liability with criminal liability because so many people who might have tort claims simply wouldn't bring them for cultural purposes and sort of just not really seeing the courts as an appropriate venue. So I think these are asking really interesting important questions that sort of that I think raise some interesting things surrounding a couple of things that are relevant for my research, but not really relevant for you guys. So I will just mention them briefly and then move on. But like they're related to the dispute generation process, right? How people get from having been injured in some way to the point where they are ready to file a lawsuit, right? And there's a lot of gates in that process that they have to pass through, and at each gate, more disputes sort of the process. So that's one piece of this, and the other piece of this relates to the systemic legitimacy. So like if people don't view the courts as being a place where ordinary people can obtain justice, then that's going to affect their willingness to bring claims, right? And I think that if both of those present puzzles for tort law and for the judicial system more broadly, in that we should be asking ourselves, how do are these problems, right? First of all, because you may decide that you don't care if people don't know that they can go to court, or you don't care that the gatekeeping burdens prevent people from bringing valid claims. But you may think that that's a problem, and if you do, then how do we solve it, right? And one solution, the solution that's suggested by the proposition, is to simply move all of those disputes into the criminal law, right? What problems would that bring into the process? What are the arguments that you came up with for against?
Sir, if you move everything under criminal liability, would you still be able to receive damages?
That's a really great question, right? And I think that's a really important point, in that the remedies for criminal liability do not flow to the injured party, right? They flow to the state. So even in situations where you impose a fine, right, even if it's a fine that is equal to what tort damages would be, those damages do not necessarily go to the injured victim, right? You can design a system where the victim is compensated in some way, but that introduces another change, right? You're not just moving cases from tort to crime. You are now introducing this social safety net system for injured parties, right? So that's perfectly fine, but it creates a different system. Rihanna says here in chat, most people who can be held as negligent under tort could more than likely be held to a subjectively greater extreme in contract or criminal law. So I think in terms of the fear factor, people would be more scared of criminal over torts. Jordan, I think you're raising a really important point, but I want to address Rihanna's first and then come back to you, because I think I think what you've got is really important. So Rihanna brings up the point of the different standards of proof. So let me throw up the whiteboard for just a second and show you guys something. Okay, so let's assume a distribution of disputes. Okay, this is a normal distribution, not really that don't worry about what normal means in this circumstance, but the x-axis is the probability of negligence or misconduct, right? The probability that the fact finder finds that the defendant did something wrong. And the vertical axis is the number of cases, okay? So in tort, let's do this. In tort, liability is imposed for every case to the right of the blue line, right? So if we have the balance of probabilities, we have, you know, every case that has 50% and something in addition to that goes that the defendant is found liable. But in criminal cases, the standard of proof is much higher, right? So here's the tort liability cutoff. And here is the criminal liability cutoff. And so all of these cases, right, that are between the blue and the green line are cases that tort would be able to find redress, but criminal law is not. Okay? So do you think that's right? Do you think that's the appropriate, right? Do you think that the system should be designed to secure redress at the blue line or the green line, assuming that those are your only choices? Okay, we may have an opportunity to discuss like intermediate systems later in the semester, but for now, blue line, green line, which one do you think is more just? Go ahead, Carla Ray.
Sir, I don't think they're mutually exclusive. Like, I don't think it has to be one or the other. I
Okay,
think in some cases, just like how you had a question on a tutorial sheet about somebody shooting their nemesis or something like that. And in that case, it has both tortious and criminal liability.
Mhm.
So sometimes it's not really a question of either or. There are some cases that are purely tortious and then others that are purely criminal, but I do believe that they have to converge when
I mean,
it is appropriate and in the best interest.
so you're absolutely right about that in terms of the status quo. Okay. But the proposition is suggesting that we eliminate tort liability and replace it with the criminal law.
No,
Okay?
just because of your original point that the damages don't flow to the damages flow to the state, and it does not always, that does not necessarily mean that it will put them in, restore their original state when that happens. If they can't, because there's not a personal damage or to their injury. It's something for the state and it goes into the state coffers, and then the person doesn't benefit, although they were personally affected.
Right. I think that's a really important point, is that criminal law serves the state's interest, right? Serves the state's purposes. Tort law serves the interests of injured parties. Okay. And to the extent that those interests diverge, then you are engaging in trade-offs for every case that you move from a tort process to a criminal process, right? There are things that you are giving up by making that move. So I think that that's absolutely right. Okay. So now, Jordan, I want to come to your point. Can you expand on this a little bit because I want to make sure that I understand it. Can you explain it a little bit more?
Hi, sir.
Hi.
I was just saying that, people may have different conceptualizations regarding justice. So even though a tort would may be more beneficial to them, they may see going under criminal law, bringing an action under criminal law as justice. So it's neither here or there.
Well, I don't know that I would say that it's neither here nor there. I think that it's very important, right? I think that, one of the things that we know that is an important component of the systemic legitimacy literature, right? When people ask, when researchers go out and ask people, do you view the court's decisions as legitimate? All right. One of the most important components in preserving that legitimacy is that people feel like they got a chance to be heard and to tell their story. And, this is part of why, like, as an attorney in private practice, one of the most important things that I did was meeting with people whose cases I wasn't taking. And to say, these are the reasons why I'm not offering to represent you. It usually amounted to, I don't think there's a claim here, but I would say it a little more nicely than that. And with very rare exceptions, I always concluded that meeting by saying, look, another lawyer may see this case differently. My business partner's phrase that I stole from him was, I am not the God of law. And so I would always end the meeting by saying, here's the name of another attorney that you can call. You can mention that I referred you, and they may see the case differently and they may be willing to offer you representation. I think the one time that I didn't do that was when the potential client was arguing. I had actually offered representation. The potential client was arguing over the financial terms. And at one point they said something like, I'm not trying to Jew you down. And that was the end of the conversation. I just said, you know what, I don't think I'm going to be able to represent you, because anybody who makes those kinds of anti-Semitic comments is not going to be my client. Okay, so Mystique says, I understand that there's a high threshold for criminal law and not necessarily tort. The claims that people make in tort aren't illegal per se, or am I wrong? Because if they aren't illegal, then how could they be compensated under criminal law or contract law unless there's some kind of connection with the other two laws? So I think that this is getting into some of the issues that we've talked about before, right? That there are certain types of conduct that are torts and are also crimes. And then there are things that are only torts, and then there are things that are only crimes, right? So for example, in jurisdictions where certain kinds of sex work are criminalized, probably not tortious. Could be wrong about that, but but yeah, so that would be an example of something that's a crime but not a tort, right? Sometimes you hear them referred to as victimless crimes, right? That's a signal that that's probably what you're dealing with. So I have a private question. How many cases have you tried and what is your success rate? Email me that question so that I don't forget it, and I will email you an answer. If you message me privately on Zoom, I won't out you as being the one that messaged me, but I may read your comment, to the rest of the class. So to the person who sent me that message, email it to me and I will email you an answer. Okay. Mystique goes on that she's thinking that contract, criminal law, and tort has some kind of connection at some point, right? And that's sort of the argument behind the proposition, is that these three areas of law are in fact connected in such a way that they don't necessarily cover unique ground. Okay. So let's play with that a little bit more. Mystique, what kind of connection do you see between contract law, criminal law, and tort law?
So when I said that, I was just thinking about the different cases, and depending on what it is, like if it's a car accident and somebody end up dying or getting like really hurt, it could be criminal and tort. So that is what I was thinking about in like that aspect, just in terms of the cases.
Yeah, and I think that's right. And certainly we have we have things related to, like, there are negligent homicides and criminal, and other forms of criminal negligence where we do impose criminal sanctions for the actual for negligence rather than the higher standard. So I have a private message just to clarify, because right now contract, criminal, and torts are getting muddy for me. And I think that's fair, right? That part of the purpose of this tutorial question of what we're doing today is to show how these boundaries are fuzzy. But the private message goes on: if you lose your leg in an automobile accident caused by a taxi's reckless driving, that would be a breach of contract because you both shared a contract for him to drop you to your destination, criminal liability for driving recklessly and causing serious bodily harm, and torts dealing with getting compensation. And I think that's, I am less certain about the breach of contract claim. I think that you would have to argue that there's an implied term of getting you to your destination safely, and implied terms are always a difficult theory to recover on. But this one seems reasonable to me. So, but absolutely for criminal liability and tort liability, right? Those both could apply in this case. The contract, maybe that's a little bit tougher, but certainly possible. Okay. Tamira asks, wouldn't that be a simple answer, seeing that there is a separation in terms of the wrongs, then the claims should remain separate, despite them being connected in some cases. Only where they are very alike, you then choose which way you think it should be dealt with. That seems reasonable to me. What do you guys think about it? Tamira seems to be arguing, as I understand it, that the wrong that is being done, right, the wrong that is being redressed, is a different wrong in a contract case, in a tort case, in a criminal case. And so that by itself, as I understand Tamira's argument, is enough reason to keep them as separate spheres of law. What do you guys think about that? Sarah agrees. Okay, great. Why do you agree?
I guess I can sell myself out. I was the one that sent the private message. So I think that the three branches kind of give you three different options for where you want to go legally. So what I was saying with the contract is a breach of contract, like separate torts for me deals with more like compensation for the individual, and well, criminal is dealing with the state. So they're all kind of three separate entities. Yes, from one case you can get a claim for the three parts, but I don't think it's something that should be together per se.
Okay. I think that's reasonable. Anybody else want to pipe in? No? Okay, yeah, go ahead, Mystique, go ahead. That's what we're here for.
So it's like not is like it is something that happened, I believe, yesterday. One of my mother's friend, his well, I could say his child mother, she made the baby yesterday, but while she was in labor, she was telling the nurses that she feels like the baby is going to come, but the nurses keep telling her to don't push yet, don't push yet. Eventually, when she did make the baby, like the baby stay in her too long and end up swallowing I could say tutu. So I want to know, like, what could she, like, if she could file for like a claim on the tort with that, and if it would just be tort alone, or if it could probably be like a breach of contract or something like that.
Well, you're not the first person to ask me not that specific kind of question, but questions about things that have happened to people in your life. And I'll give you the same answer that I've given to every other student that has asked me these kinds of questions, which is that I am not called to the bar in Barbados or anywhere in the Caribbean. And so I am not able to dispense legal advice. This sounds to me like there might be something floating around in it. But I would encourage your mother's friend to speak with a local attorney to discuss whether there's a claim and whether it's worth pursuing. And that, unfortunately, that's the best I can offer, since I am not licensed to practice law in this jurisdiction. Okay, so what questions do you guys have? Subject to the limitation that I can't dispense legal advice. What questions do you guys have as we sort of head towards the ending?
In the readings, I saw a case, a rule, Smith v. Selwyn rule.
Yep.
And it further stated that it was discarded in Jamaica. So I believe that may come into, I guess, application based on the discussion we're having relative to the relationship between whether I can file a civil claim. Yep. As opposed to a criminal claim. I know that the jurisdictions were separate and exclusive. So yep. The old practice was that you would try to have the criminal case treated with and dispensed with first. And once that has ended, you would be able to file a civil matter, I suppose. But now, is it that given this evolution, that across the board within the region or in different jurisdictions, you have the option equally to file a civil or criminal case going forward?
I saw the same discussion that you did in the textbook. My understanding is that the Smith versus Selwyn rule has actually been made more defendant friendly, in that you can't prosecute your tort claim until the criminal proceeding is dispensed with in some form or fashion. And that does not mean that a prosecution has to be brought. It just means that you have to, the state gets the first bite at the apple, so to speak. But the statute of limitations still runs while you're waiting. And so what I read actually said that what you have to do is you have to file your civil lawsuit and serve the defendant so that you can start, so that you start the process, and then the civil lawsuit is stayed until the criminal proceeding is resolved. So that's what I was able to track down in my understanding, is that the Smith versus Selwyn rule has not necessarily been done away with, but it has been changed and strengthened. So I have a private question. Can one ruling not undermine the other in the event that the judges disagree? And the answer is no, because the proof standards are different, right? So being acquitted of the crime does not necessarily mean that you won't be held civilly liable. And because of the Smith versus Selwyn rule, because the criminal prosecution has priority, there is no way for the tort ruling to be used as evidence against the criminal prosecution, right? You won't have a situation where the judge in the tort case rules that you are not liable on the balance of probabilities, and then later the judge comes alongside whether you committed the crime beyond a reasonable doubt, right? So that's how the Smith versus Selwyn rule sort of plays out in terms of the sequence of decision making. If you're acquitted of the crime, that doesn't mean that you're not civilly liable, because it may just be a question of not meeting the higher proof standard. So one last question in a private message. There's something that basically says you shouldn't sue a man who has no money. So let's say you do go ahead with the criminal claim first and they do pay a fine to the state. Can't they stop you from going against him in tort? So there is nothing that says you can't sue a man who has no money. What you probably saw said shouldn't. And the reason for that is, why waste your time and your money chasing after this, right? We call these, in my practice, we used to call those paper judgment cases, right? The only thing we're chasing, the only thing we're going to get at the back end is a piece of paper that says judgment. And there's not going to be any money at the end of it. So why are we wasting everyone's time? You know, the point of civil lawsuits is to obtain a money redress. If you don't have that, why are we here? And that statement gets more complicated based on the case, but that's sort of the broadest version of it is, if you can't get money out of the defendant, if you win, what's the point? So that's the story. All right, so guys, I really appreciate this. You guys are really engaged and participating, and I really appreciate it. So I will see you guys on Monday, and take care, and bye.